Hello and welcome to this presentation today on estate planning and some of the common questions that arise. I'm Nicole Miller and I'm joined by Jess McDonald. We are solicitors here at Harrington Carmichael. Before we start, I'll just give you a bit of background about Harrington Carmichael itself, and then we'll move on to the topics. So Harrington Carmichael are a full service law firm. We've got over 200 members of staff and we give legal advice in pretty much all areas of law, both to individuals and also to businesses, and both in the UK and internationally. And as you can see, we've won quite a few awards for our services recently. Just a very brief list of the areas of law that we specialise in, but we pretty much cover everything apart from criminal law. So if you've got any other queries or concerns or any other areas that we can help you with, aside from sort of the private wealth side of things, then please feel free to reach out to us after today's webinar. Before we get started, as I say, I'm Nicole Miller. I am a legal director here at Harrington Carmichael and I head up the trust and tax team in the private wealth and inheritance department. And I'll leave you to introduce yourself.
Yeah, so my name is Jessica McDonald. I'm a solicitor here in the private wealth and inheritance team as well. But instead of the trust and tax team, I work in the contentious estate administration team.
So today we are looking at estate planning. So we're going to cover a number of sort of common topics, including questions about lifetime giving, trusts, wills, and deeds of variation. And at the end of the webinar, there will be some time for some questions if anyone has any questions and wants to pop it in the chat box. Over to you.
Perfect. So right on to lifetime gifting. So it's a commonly misunderstood area, but they can be incredibly useful if they are utilised correctly. It's often an area where people make many assumptions and therefore it's sort of helpful to get a bit of pointers in terms of an initial outlook. So what should you consider when thinking about making a gift? It's really important to consider the reason why you are making that gift. You should only really make a gift if you can afford to do so, and that the intention of you doing so is to benefit the recipient rather than to deprive your estate of assets. Lifetime gifts can be a great tool for estate planning, whether or not you need to be considering inheritance tax, because you can ensure that in your lifetime, those you wish to benefit from specific assets will do so. It's important to note that gifts made with the intention of depriving your estate of assets in the context of things like means-tested care fees can be reviewed and potentially clawed back into your estate, meaning that the gift is no longer effective and then those funds are available to be used for care. It's also fundamental to remember that once you gift an asset, you no longer have control of that asset, and therefore you should carefully consider what it is that you are actually gifting. So looking at the gifting rules, it's important to note that you're able to gift any asset that you own, including property, cash and investments, but there are limitations imposed on gifting which you have to consider if you don't want there to be tax implications on those gifts. So an individual is able to gift as much as they would like to whomever they would like to do so, but those gifts are considered potentially exempt transfers. And if the donor of the gift dies within 7 years of making that gift, the gift could reduce the nil rate band available to the estate or be liable to inheritance tax. Each individual can gift £3,000 as an annual allowance in every one tax year, but it's important, and it's also possible to roll over an annual allowance from the previous year, so that any unused gifting allowances can be utilised, but this step must be completed with care. There are also available exemptions, the two most common being the small gifts exemption and gifts from excess income. So the small gift exemption applies where an individual makes a gift of gifts up to the value of £250 to as many people as possible within one tax year. It is important to note, however, that if the value of the gifts to an individual exceed £250 across the whole tax year, then the exemption is lost and instead the values of that gift will be deducted from your annual allowance. The gifts from excess income exemption does not have a limit on value. However, all gifts must be able to be shown that they are out of surplus net income and not capital, and that the income is not needed by the donor. And so for this reason, a detailed account should be kept of these gifts and your income and outgoings for the year in question. Obviously, the rules around gifting are rather complex, so legal and/or financial advice should be sought if you plan to utilise this estate planning tool. So what is a gift with reservation of benefit? You might have heard of it, you might have not heard of it before, but it could definitely affect you if you accidentally make one. So a gift with reservation of benefit is where the legal title of an asset is gifted, but the benefit remains with the donor. The most common example of this is a property where the occupiers or parents gift the property to their children, but remain living in the property and not paying things like market rent. In this situation, the 7-year period doesn't apply because the occupier will have retained the benefit, and therefore the value of the gift, being the value of the property in this circumstance, will be clawed back into the estate, and inheritance tax can be applied on this basis. Again, avoiding gifts with that reservation of benefit is a very important aspect of estate planning, for which you should definitely seek legal advice. And then taper relief, it's one that some people have heard of and some people have not at all. It only applies to gifts made which exceed your annual £3,000 allowance and any available nil rate band to your estate. And it reduces the tax that would be due upon your death if you fail to survive those 7 years, as aforementioned. This only applies if the donor has survived 3 years post the date of making the gift. So taper relief, simply put, will reduce the tax applied to the gift on a sliding scale between 3 years to the 7, meaning that the closer the donor was to the gift being exempt from any tax, the less tax will be applicable. And then, Nicole, I think I'm passing over to you.
Yeah. So, as we just heard from Jess, making lifetime gifts can be a useful way to reduce the size of your estate for inheritance tax purposes. But there are obviously risks involved with making outright gifts to individuals. And an alternative that might be suitable in some circumstances is to make gifts into a trust. Now, this isn't appropriate for everyone, but we'll sort of go through the basics. So what is a trust? Well, a trust is a legal instrument or legal arrangement where an individual, known as the settlor, transfers assets to the trustees. The trustees then have a legal duty to manage the trust assets in accordance with the trust deed on behalf of the beneficiary or beneficiaries. How the trustees must act and whether they have any discretion will come down to the type of trust that it sort of has been prepared and the terms within that trust. Although there are different types of trusts, some of which are more suitable in specific circumstances than others, the most common types tend to be a bare trust, a life interest trust, and discretionary trusts. So a bare trust is where the assets are effectively held by the trustees on a nominee basis for the beneficiary. A life interest trust is where the assets are held by the trustees for the benefit of the life tenant in the first instance. The life tenant is then the main beneficiary of the trust and is entitled to the trust income or to live in the trust property. When the trust comes to an end, the deed will then stipulate what should happen to the trust capital. Depending on the terms of the trust, the trustees might have some discretion or flexibility to pass capital to the life tenant or to other beneficiaries, but this will sort of be on a case-by-case basis. A discretionary trust is often the most sort of flexible type of trust. And with the discretionary trust, the settlor would name a class of potential beneficiaries and would appoint trustees to manage the funds on their behalf. However, due to the nature of the trust, the trustees will have complete discretion as to how they apply the funds to the beneficiaries. As they are only potential beneficiaries, none of the beneficiaries named are absolutely entitled to receive anything from the trust, but the trustees can decide who should benefit at what time and to what extent. But the trustees should be guided by any letter of wishes or wishes that the settlor might have left when they prepared the trust itself, and they've always got to ensure that they're acting in accordance with the trust deed. So when it comes to estate planning, the discretionary trust is often the most popular choice as it offers the greatest level of flexibility. It can also offer continued levels of control as the settlers can be trustees when they set the trust up. And therefore, this avoids the lack of control concern that Jessica was talking about a moment ago, and can also ensure that the trust assets are not instantly lost in a divorce or future financial proceedings, all the while they're kept in the trust. The trusts aren't right for everyone, and they often get a lot of bad press where they haven't been used for the right reasons. So as Jessica mentioned a moment ago, not everyone needs to worry about estate planning for inheritance tax purposes, and you may not need a trust, or it may not be something to sort of be concerned with. Trusts have historically been recommended to people as a method of safeguarding their property when it comes to inheritance tax and care fees. But if you continue to live in the trust property, then as Jessica said a moment ago, you would be considered to be making a gift with a reservation of benefit or a GROB. unless you're paying the full market rent to the trustees for living there. Likewise, if you need to go into care and the local authority believes that you have only made this gift to avoid paying care fees, then again, they're going to consider that you've taken steps to deliberately deprive yourself of these assets, and they can then take steps to set the gift aside. So it's really important that we look at all the circumstances as to whether a trust is the right option at any given time. So when is a trust right? If you've got assets in your estate that you no longer need to benefit from and you want to pass these on to the next generation, then a trust might be something for you to consider, especially if you've not decided exactly who in the next generation you want to benefit. You don't quite want them to have the money yet, or you've got concerns that the individuals may not be ready to manage those assets due to their age or their current sort of financial maturity, or there might be concerns about their sort of current spouses or financial position. In these cases, then a trust gives the trustees the ability to consider the circumstances over time, and the ability to make decisions at a later date as to who should benefit and when. Because you're making the disposal into the trust now, the 7-year clock can start to tick straight away, and the gift into trust is effective for the assets to come out of your estate. But what are the implications of setting up a trust? There's obviously lots of things to consider aside from simply getting the assets out of your estate. Firstly, we need to think about the tax implications of the trust itself. Which trust is going to be the most suitable trust for the circumstances that we're faced with? If you're looking to give more than your inheritance tax-free sum into the trust, then there might be an immediate inheritance tax entry charge on entry setting the trust up, which is currently at a rate of 20%. There's also some ongoing tax considerations, as the trust is going to be subject to income tax and capital gains tax on the income and gains within the trust. And depending on the nature of the trust that we've created and the value of the assets in the trust, there might also be inheritance tax charges at every 10-year anniversary and whenever assets exit the trust. There's also ongoing compliance matters to address, including maintaining trust accounts and reporting to HMRC. So there's quite a lot to consider when it comes to thinking about setting up a trust as part of your estate planning. And for all of these reasons, it's obviously crucial that you seek legal advice about the specific circumstances that you're faced with before taking steps to set up any trust. Over to Jessica.
Perfect. So another really, really important tool, probably one of the most essential tools for your estate planning, is a will, because without it, your estate distribution is governed by statute rather than by your wishes. So why do you need a will? Well, the answer to this is fairly simple. It's all about control. By creating a will, you're ensuring that your estate passes to those who you wish to benefit rather than by statutory provisions. Further, wills can be utilised in estate planning through the inclusion of trusts, as Nicole's been talking about, which can help protect capital for your loved ones in the event of circumstances beyond your control after you die. So how often should you update your will? We would say that you can update your will at any time, all the while you have your mental capacity, but you should review your will every 3 years. With every major life event, including births, deaths, and/or marriages, and if your finances change. Your finances can change substantially or in a minor manner, but still you need to be looking at your will and seeing whether that still reflects both your family circumstances and your financial circumstances to move forward. So what are the implications of you not updating your will? This will be that your estate passes in line with previous wishes and may skip new beneficiaries that you might have wanted to include, or beneficiaries may have predeceased you and therefore their share is not administered how you would have wanted it to have been. The implications of not creating a will at all, as I've said before, is that your estate will be administered in line with the intestacy rules. Now, what actually is intestacy is a big question. So when someone dies without a will, they have died intestate. Their estate will therefore be administered in line with the intestacy rules, which dictate the order in which relatives are entitled to your estate. Generally speaking, the rules ensure that those closest by blood are benefited first, and any relative more distantly related, regardless of your personal relationship, are unlikely to receive benefit from the estate. Obviously, this means that the rules don't take into account your personal relationships, i.e. you might like your cousin more than your mum, but if you don't want to benefit your direct family, you must create a will. Additionally, it's much easier to administer an estate with a will that appoints executors rather than dealing with an intestacy, and therefore you should create a will in any event. If you do not have a will, or you have an outdated will that you'd like to look at, I would strongly advise you seek legal advice and ensure that your estate is best protected for your loved ones. Back to you.
So having sort of spoken about wills and the importance of using wills in estate planning, I'm now just going to briefly touch on deeds of variation, because these can also be a really helpful tool when considering your own estate planning position. So if you've been left money from someone else's estate that you don't need, then a deed of variation is something that you might want to look into. So with a deed of variation, you have the ability to redirect your inheritance to someone else. This might be useful if you've received a large portion of your parents' estate, but you already have an inheritance tax liability of your own, or you just don't need the assets, or perhaps there's other people that you think would benefit greater by receiving a share of the inheritance that you would otherwise have received. So a variation must be in writing and ideally is done by a formal deed. The original beneficiary of the estate is the one that enters into the variation to vary their inheritance and can redirect it to whoever they want. The effect of the variation is that the terms are effectively written back into the will, and the variation is treated as if the will had always provided for the new beneficiary in this way. Whilst there's no time limit on entering into the deed of variation itself, for the variation to carry out the potential tax benefits, it must be completed within 2 years of the deceased death. If it is completed within that 2-year period, it will be treated as if the will had always provided for the new beneficiary for inheritance tax purposes, and therefore the new beneficiary is not treated, the old beneficiary is not treated as making a lifetime gift. Instead, it's as if the deceased had always benefited that new beneficiary. You can also include an election in the deed of variation in relation to capital gains tax, so the new beneficiary inherits the assets at the value as at the deceased death, which then avoids any capital gains tax liability arising as a result of the variation. It's obviously important to note that an asset can only be varied once, and therefore once the deed of variation has been entered into, a further variation cannot take place in relation to the same asset. But having said that, if you've entered into a variation in relation to a property that you were due to inherit, you could enter into a different variation, a subsequent one, in relation to cash or shares at a later point, as long as you do so within that 2-year period. So it's obviously important to sort of consider who you're now looking to redirect the assets to and whether they actually want them, because they're not going to be able to then vary it again after that point. An alternative way to divert your inheritance is by way of a disclaimer. Again, this has to be in writing and completed within 2 years of death, but a disclaimer is much less flexible. If you use a disclaimer, you have to disclaim the whole benefit of the asset before you receive any benefit from it. However, if you're entitled to various different parts of the estate, you could disclaim just one part. So you could disclaim just the property interest and still receive the shares and things like that. But the asset in question will then pass in accordance with the will to the next person entitled. So you've got no control over who's going to benefit from those assets. Depending on the terms of the will, this could result in part of the estate actually passing in accordance with the rules of intestacy that we spoke about a moment ago. For this reason, the deed of variation is normally the most popular solution. Again, if you want to retain any element of control over the assets that you're varying, it might be possible to create a trust by way of the deed of variation, a bit like what we touched on previously. But it's important that you seek advice before exploring this option, as there could well be further tax considerations that need to be contemplated, as you would be considered to be a settler of that trust for income tax purposes and other reasons. So if you are due to inherit assets and you don't feel that you need them, or you think that other people might be better placed to benefit from them, or you want to explore any other options generally in relation to your personal estate planning, we'll obviously be more than happy to assist. That's pretty much all we've got time for today in terms of the bits that we were going to cover. But if anyone's got any questions or queries, then please feel free to pop it in the chat box. So if there's any other questions or follow up after today's session, we're more than happy to help you. We specialise in a range of private client matters, so it's not just estate planning and wills. We can also assist with sort of preparing lasting powers of attorney, dealing with the administration of estates, dealing with cause of perception matters and things like that. Okay.